We are live. Welcome to the House Judiciary Committee this Friday morning, May 22nd, and we're looking at draft number 3.1 amendment on S193. And over to Eric for a walkthrough.
Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here, as the chair was saying, to look at a revised proposed amendment to S193 from Reps. Burdett et al. A couple of additional sponsors you see added there. Actually, I should pause for a moment. Is everyone looking at version 3.1?
Yes.
All right. Perfect. Thank you. So a few more sponsors added in the beginning, and then the sort of stepping back for a moment for the big picture to describe, because I think this structure was not the structure yesterday when we looked at the previous version of the amendment. And the structure is, the proposal is that you may recall that the amendment from Representative Burdett et al. That we were looking at yesterday removed some of the limitations on Department of Corrections participation in the operation of the forensic facility, and put in place that it was the Department of Corrections who would be in collaboration with the respective departments within the Agency of Human Services. So it's not just the departments themselves, it's DOC in collaboration with them. So that remains, you'll see that in the language as we look at it, but at the same time, that language would be in effect for the next 3 years. So the limitations on DOC involvement, the fact that it's DOC in collaboration with these other departments, that would all be the way this program would be in effect for the first 3 years, because it's during that 3-year period that the interim forensic program is established by emergency rule from the Agency of Human Services. So they have to propose and establish this emergency rule that will run the interim, because then it goes to the issue that the committee's talked about, which is that they're pending the implementation of the final permanent program. There are still people who would qualify for this type of treatment, and what happens in the meantime. And that's the proposal. In the meantime, there's going to be this emergency rule that is also consistent with the amendment you looked at yesterday. DOC is involved, and they do the supervision in collaboration with the other departments. That's the way it lasts for the 3 years. Then, at the end of that 3-year period, specifically July 1st, 2029, it's on that date that the versions of the language that you had looked at that had come out of the other committees with some of their amendments, which was language that had a more limited role for DOC. Remember, they provide security around the perimeter and at the admitting area and that kind of thing, but otherwise services generally provided by other departments within the agency. Then that comes into effect. So the idea is that during this interim period, it's this way with DOC, 2029, again, for the next 3.5 years, I guess it is roughly. Well, actually, really, it's May, closer to 3 years, to July 2029. That you'll have plenty of opportunities as the legislature to look at what's going on and revise language if you need to. But there'll be this interplay. In the meantime, you have the DOC being the lead actor on the supervision of these people who are released from the facility. And then that sunsets in 2029. And on that same day in 2029, July 1st, is when the existing provisions that were in the version of 7.1 come into effect. Does that kind of make sense in the big picture as to how that is going to happen? Yes. All right. So that's the idea. And so I'll try and note as we go through the walkthrough, which provisions are in place now and which ones are temporary and which ones are permanent. So first one, legislative intent. That's the first instance of amendment on page 1 of version 3.1. You'll see, so it illustrates the concept I was just talking about. So this intent, you see the first sentence that it's the Secretary of Agency of Human Services who establishes and operates a locked secure forensic facility. And this is new language, lines 10 and 11, by July 1st, 2029, because this intent is talking about this permanent facility. It has to be done by that date, roughly 3 years from now, for competency, restoration, evaluation, et cetera. And then the second sentence, which had not been in the previous version of the amendment, is now back in because this is the piece that is, again, conceptually talking about the limitation on DOC involvement, generally not involved, but may provide security services at the admitting area and the outside perimeter if it's co-located on a facility grounds. But this, again, that applies only to this permanent facility that goes into effect July 1st, 2029. So that's the idea. In the meantime, how's it going to be? Well, it's going to be, as I mentioned, with DOC taking the lead supervisor role in collaboration with the other AHS departments. So that's the first instance of amendment. The second one starts in the bottom of page one, and goes over on the top of page 2. This has to do with the feasibility plan that is in effect, would go into effect now or July 1st of this year, I should say. And the idea here is that, again, the same issue of what's going to happen in the interim was also addressed in the feasibility plan in one place, subdivision 12, which you see on the top of page 2, because I believe it was HCI wanted to make sure that there was something in place, the same thing that the committee is thinking about, what's going to be in place in the meantime. And they wanted to say, all right, well, in the meantime, the forensic facility could place the person out of state. So that's still there. But they had also had there in their language that said that it could be at a DOC facility as long as the contracting entity wasn't somebody who contracted with DOC, if I remember correctly. So that language isn't here now, but I'll defer to the chair on that. I think that's one of the pieces we just talked about that they want to see back in.
And that will be when we get to the we can discuss.
Right. Okay. Yeah, because you could see it there too. All right, so that's second. Again, okay, this third one is pretty straightforward. You see this is page 2, line 5. This is the report back to Justice Oversight. And this is just that they wanted to add that, remember, because I mentioned these emergency rules have to go into effect by December 31st of this year. And the report back to Justice Oversight has to come 2 times at the August and November meetings. So they just want that report to also address how the emergency rulemaking is going. It's going to be going on during that period, presumably. That's the third instance. The fourth instance, now these are the sections that that the committee looked at essentially yesterday, in that I'll give you an example just so you can see it's better to sort of look at it rather than let me try and describe it. So if you look over on subdivision 5A, which I believe is on page 6 of your version of the amendment. No, I'm not seeing. Oh yeah, I'm right. Page 6, line 14. So if you look there, or sorry, a little bit further down the page. And this is about this. So this is when someone has been found non-restorable and not dangerous, so they have to be released, right? That's the general process. They're not restorable, but they're not dangerous, so release is required subject to the supervisory conditions that you've illustrated. So the question was really, and this everybody's been sort of grappling with this. It's my combination of the words wrangling and grappling. Yeah, discussing that question, which is who's doing the supervising, right? And everyone agreed there. They do get released under supervision, but who is it? And so you'll see here, this is the same language you looked at yesterday. This is the version that was in Representative Burdett et al.'s original amendment. They're supervised by the Department of Corrections, that's the bottom of page 6, then over onto top page 7, in collaboration with the various departments at AHS, as opposed to the original 7.1 version, which didn't have DOC in there at all. It was just those departments. So this stays in effect. This is the version we looked at yesterday. It's DOC that's doing this. But again, keep in mind, this is for 3 years, right? Because this is one of those sections that lasts for 3 years, and then in 3 years, it sunsets on July 1st, 2029. And what comes into effect? The version 7.1, which is this exact language, except that sentence, that line would be struck, line 21. It wouldn't be and supervision by the Department of Corrections in collaboration with, it would just be over on top page 7, Commission on Mental Health, Dale, etc. So that's the structure of the way it would work. Again, as I mentioned yesterday, very reminiscent of Raise the Age, the concept of one thing in place for a while, and then down the line, something else comes into effect, but it's further out in the future. but that's the principle.
Eric?
Yeah.
Thank you. So Eric, can you I think you might have just directed us here and I missed it. Can you tell me again where that is made clear? Did we get to that or?
Which part? I'm sorry.
Sorry, yeah, like where it's made clear that in the future state where the facility exists.
Yep.
That for instance, in the language you were just reading on page 6.
Yep.
That the supervision by the Department of Corrections in collaboration with would like drop out.
Yes, I'll do it because it's a good thing to know. Yes, it's in the effective dates.
Okay.
But we can jump ahead for a second. See? Right on top of it. And so we can wait or we can look now.
Okay, yeah, no, we can,
Sure?
that's fine.
All right. Yeah, well, keep in mind, so this was section 9 that we were just looking, right? It might not be a bad idea just because it illustrates it once, just to look for a moment at the effective date. So turn to the very end. And you'll see, if you look at page 25, right? And you look at line 5 of page 25. We were just looking at section 9, right? And that's the one with VOC involvement. But what happens in 3 years that gets repealed? July 1st, 2029, on line 5, page 25. And what also happens on that date? Look at line 9, page 25. Those are the 3 sections, 2, 4, and 5 of 7.1 that just had the departments involved rather than VOC. And that comes into effect on July 1st, on that same day. So on that date, this stuff goes away, the other stuff comes in.
Gotcha. So the
And 3,
difference- sorry, go ahead.
no, I was just gonna say, in 3 years between now and then to
Figure it out.
figure it out and make any changes you want.
Yeah. So the difference between draft 3.1 and yesterday's draft is that yesterday's draft was replacing sections in the bill as voted out of this committee.
Yep.
And now in 3.1, you're leaving those sections in place and adding sections with the different language, the interim language.
Yeah, I think that's one way to phrase it. You're adding the interim language. You could also say you're replacing the language, but for 3 years only.
Yeah.
Yeah, but yes.
In new sections of the bill, like,
Yes, new sections of.
okay, thank you.
Yep. At the very end.
Yeah, great, thank you.
Yep. All right, so that brings us to, same idea though, but page 7 now, same thing, you'll see a couple of different times, page 7, line 7. Again, it's under the version of 7.1 you looked at, it was DMH, Dale, and Department of Health that were doing the supervision. Here, it's the Commission of Corrections, you see that, line 7? So, again, difference for how it would be operated for the next 3 years. It'd be Commissioner of Corrections for that period of time. And you'll see also that there's a lot of language in this amendment that is unchanged, but it's only here because my understanding was, and it's true, that the committees wanted to see the whole sections in the amendment rather than just, because remember the previous version, it was just strike these 3 words, put in these 3 words instead. They didn't want to do it that way. They wanted to be able to see the whole thing and understand what's going on. So even though there aren't really any additional number of changes than what you saw yesterday, you're looking at it in the context of the whole section. Right? So the next one of those individual changes would be on your version, subsection G, which is over on page 11, top of page 11. So again, it's almost, what's really happening is the changes from Representative Burdett's amendment yesterday are being integrated into the section as a whole rather than set out as individual instances of amendments. So you'll see that the change here, which is on lines 1 and 2, the first one anyway, page 11, it just adds, because this is who's doing the monitoring of the person after they've been released. Because remember, someone has to monitor and make sure that they're in compliance with their conditions of supervision. And the way it had been phrased was just the commissioners. Here it says it's the Agency of Human Services medical director in consultation with the commissioners, which makes some sense because you have somebody, if you look down to the next line 5, somebody has got to tell the court right away if the person is not in compliance with their supervision. Because if that's the case, then the court has to order the person back to the facility immediately. Then look at line 13, similar, it's the medical director then, as soon as the person gets back, because that isn't necessarily going to happen instantly. The medical director could become aware that the person's not in compliance. They say, all right, we got to get this person, we got to ask the court to order this person back. That might not happen in 10 minutes. Maybe they don't know where the person is right then. Maybe it takes them a day or two to get the person and get them back to the facility. To account for that potential time gap, line 13, the medical director then has to notify the court as soon as the person gets back to the facility. So as soon as they get them there, they let the court know, because the court has to have a hearing ready. Because in that case, you've, again, confined someone involuntarily. Due process requires a hearing. So that's what that sets up. But it's the medical director who's the point person who lets the court know that that's what's going on. And again, that was what was in the amendment yesterday, but it's integrated here instead of being separate in an instance of it. All right, so that brings us to the next section, which is we were just talking about. This is all the not competent to stand trial population. Remember, there's also an NGRI population that goes to the facility, and that's dealt with in the next section, which on your version starts on page 13. And all this is just the exact same changes that we just looked at in terms of the agency, the medical director does the exact same thing. That's over in subsection F on page 17 of your version 3.1. Again, you'll see the same thing I just mentioned. It's not just DMH, DAO, et cetera. It's the Agency of Human Services medical director in consultation with them, who monitors compliance, lets the court know if the person's out of compliance and needs to be brought back, and then let the court know when they are back so they can set the hearing. That's all on page 17, sub F, and that's actually the only change to that section of the bill. So that brings us over to, on your version, page 18, which is the forensic facility definitions. Again, we're talking about a section that is in effect for 3 years. July 1st, 2029, the section goes away, and the section that's in version 7.1 comes into effect. And one of those distinctions that is on page of your version, page 19, which is the definition of forensic facility. You'll see the page 19, line 2. We were looking at the idea that instead of, because in 7.1, it called this a licensed therapeutic community residence, licensed as a therapeutic community residence. So what you were looking at yesterday was instead replace that language with suitable clinical setting. And what they were talking about in HCI was, well, is that term defined? I said, no, it was not. I said, well, that's really kind of squishy. Do we even need to say anything there, really? And from a legal perspective, you don't. So you could. So the proposal is just to say, just strike the words, a suitable clinical setting. You just strike it. And because you really already covered the concept in Romanet 1 anyway. So it would just say, forensic facility means a locked, secure facility that provides, a locked, secure facility where? So you strike the words that through setting, where the Agency of Human Services provides for the secure, competency restoration, evaluation, stabilization, treatment, and care of persons with a qualifying condition, etc. So that's the idea. Everybody get that? I was just explaining, Representative Lalonde, the other proposal from HCI to strike the words suitable clinical setting and just not have that at all.
Not necessary.
Right, not necessary.
Well, it's the fact that this is going to be potentially, I don't know that there's any individuals that qualify who will be in the women's facility. And we'd be hard pressed to say that any place there would be a suitable clinical facility. Same possibly with Springfield. So that's why folks wanted to take it out in corrections and institutions. The main point is that we're providing this programming in the interim. So.
All right, so that brings us to subsection B, which is this general discussion about the way that the forensic facility is run and who has what responsibility. And so you look at page 20, subsection B. This is the general statement that Secretary of Human Services establishes operates the locked secure forensic facility, again, for the purposes that we just mentioned, competency, restoration, evaluation, et cetera. And then line 4 in the next sentence, forensic facilities, clinical forensic and competency restoration services shall be overseen by the HS medical director. Remember, this is where version 7.1 and the HCI amendment had that sentence that limited DOC's participation in this. This is where it said DOC shall not play a role in, et cetera, et cetera. So this preserves Representative Burdick's amendment that you looked at yesterday, which does not have those limitations on DOC participation. So they can participate in that way for the next 3 years. So that sentence comes back in 3 years from now, July 1st, 2029. That piece that was in the version 7.1 that, and I can read it to you if you want, the Department of Corrections shall not play a role in the forensic facility's operation, the provision of services, or internal security, except to provide security services for this facility at the admitting area and around the outside perimeter if the facility is co-located on the grounds of a correctional facility. Now, that sentence is still struck in Representative Burdick's amendment because you see it would have been, if it were here, page 20, line 6. That's right where after the word director, period. But it's not, because for the next 3 years, that limitation doesn't exist. DOC can participate. But then in 3 years, 2029, that's when it comes back in. That's that whole distinction that I described in the very beginning.
Angela.
So I'm just noticing that we have on lines 9 and 10, again, in a suitable clinical setting. Would it be?
No, that's coming out there too.
Okay.
Yep, sorry, I meant to mention.
Okay.
Yep, exactly.
And then I just remembered yesterday, I think there was mention of perhaps calling this a forensic and competency restoration program rather than a secure forensic facility.
Yeah, we'll see that. Yeah,
It's in the emergency rules.
Okay.
That's what we did that.
It's in the emergency rules, but not in all the, like, we're still calling it a secure forensic facility.
Yeah.
I think for the permanent one is called that. I think this is the
Right.
permanent.
Okay, we're in the permanent one on page 20.
No. So here's the thing. So the rules are going to provide that we're going to be consistent with all that, with those sections. And my understanding to have changed all that at this late date would potentially you miss something and it doesn't really impact if we're just saying consistent with, I think the language, that's my understanding, Eric, from our conversations. If I'm right.
Yes, that's right. Can't go back in there and change that term every time. And you still have the forensic facility term defined. Like it's defined on page 19, both in the existing section, or the one that goes into effect on July 1st, and the one that goes into effect on 2029. But it's defined differently in the sense that the one that comes in 2029 is the licensed therapeutic, what that phrase is that now I can't remember the name of it. Licensed community residents.
Okay.
But it's defined different in each version.
Okay. Yes, I sort of understand that, but then again, this is new language, so it wouldn't be going back and I'm not talking about changing it in the bill. I'm only talking about the amendment. And so I think I hear you saying that it's not necessary, like it's still going to be, and it may just be semantics, but I want to just understand that since we were talking about it yesterday and clear that up. It's not a forensic facility. We're talking about a competency restoration program, a forensic competency restoration program inside a corrections facility. In the interim, in the bridge, what I'm calling the bridge.
Right, and to go through and try and sort all of that out through all of these operative sections now is virtually impossible.
In this amount of time.
Correct.
And that's why we're doing it this way.
And that's why we're also going with the consistent with, instead of saying, actually.
Yeah, I get that, sort of. I just, because it's new language, I'm confused about why. I'm not talking about going back and it's fine. I just don't understand why when we are writing new language, you can't say what you mean, but that's okay. We've got it figured out.
All right, so the Representative Arsenault just referred to the other suitable clinical setting term that has to be changed. So that will be. The other change in the in this section is over, it has to do, and it's fairly straightforward, it's subsection. It's on page 22. So if you look at, this is just the consultation, remember that it adds on line 18. The version had said that Secretary of Human Services shall regularly consult with, for purposes, for all the duties required for this, these two sections, with the commission, the various commissioners, and it just adds line 18 to see there, the Agency of Human Services Medical Director to the list of people that who have to be regularly consulted with by the Secretary. That's the only change there. And then we also talked about, and this is, you'll see top of page 23, subsection G. This was another issue that was just discussed in House Corrections. That subsection is going to be struck, subsection G. And that's the rulemaking, because this section goes into effect now. And you don't want to have two different sets of rules being in effect, because you've got the emergency rules that are already going into effect in the next section, section 12, page 23. So those are the ones that are going to last for the next 3 years. You don't need a different set of rules. That's duplicative.
He is gone.
G is going to be gone, exactly. But just so you know, in the law that goes into effect on July 1st, 2029, G will be back in, because at that point, the emergency rules disappear and you need permanence. So that's what will happen in 3 years. All right, so now we have the new section, the emergency rulemaking section, for the interim forensic and competency restoration program. You'll see that is in, I believe it's section 12. Yes, starts at the very bottom, or no, starts on page 23, line 6. And again, this has to be done, see line 8, by December 31st of this year. The secretary, in consultation with the involved departments, has to adopt emergency rules, and looking at page 11, to establish an interim forensic and competency restoration program that shall operate pending the completion of the permanent forensic facility. So you see these rules operate for 3 years until the forensic facility, the permanent one, is operational. And then it says, second sentence, emergency rules shall establish for the interim forensic and competency restoration program, and consistent with the standards and procedures of 9, 10, 11. Those are the standards and procedures that you just looked at. So in other words, that's the point that the chair was making, that those interim rules have to be consistent with the language that we just looked at that was in Representative Burdick's amendment from yesterday. So those rules are temporary, and they follow the model of the amendment from Representative Burdick. And then in 3 years, at 2029, those permanent rules are going to reflect the language that was in version 7.1, which has less POC involvement than the amendment from yesterday. That's the idea. All right, and also you'll see there's a new provision here. This is in your version, a new portion of the rules, which is over on page 24, lines 4 to 6. This was a concern raised in House Corrections about, well, okay, Department of Corrections is the one who's sort of monitoring people's compliance with their conditions, and they have to have some access to information about the person's, could be, for example, could be connected to the person's visitations with their, they have to, part of their conditions, supervisory release conditions might be, hey, keep up with your therapy, keep up with your medication, whatever it might be. How does DOC get that information? So this just provides that DOC would cooperate with and obtain necessary information from other departments about persons who are released under supervision. That's to address that specifically, so that the rulemaking has to address that specifically. And then there's some new language you also see that you didn't see yesterday, because this I put in consultation with our administrative rules attorney, Damian Leonard, he recommended adding, starting on line 18, bottom of page 24, over onto the top of page 25. There are certain standards in emergency rulemaking has to be in response to, for example, a public safety concern or immediate public safety concern, which I mentioned to him. I thought this would fit that category. He said, yeah, but you should say it expressly, just sure. So you're saying there, this is deemed to have met the emergency rulemaking standard. Over on top of page 25, generally speaking, emergency rules only stay in effect for 180 days, because at the end of that time, the presumption is it's going to be permanent rules that go into effect instead. This is not using that more common approach. Instead, it's saying we're going to keep those emergency rules for 3 years, and then we'll have the permanent rules. So this is saying, notwithstanding that, these emergency rules remain in effect for 3 years till July 1st, 2029. And then on that day, see subdivision 3, they're repealed because you don't, again, best case scenario, presumed by the bill, at that time, you'll have the permanent facilities ready to go.
It's Angel.
Okay, I don't know who to direct this question to whom to direct this question, but I'm looking at the heading of section 12, emergency rulemaking, interim 23. So interim forensic and competency restoration program. And that's the first time I think that we see this term, interim forensic and competency restoration program. And then it says on lines 11 and 12, establish an interim forensic and competency restoration program. Everywhere else, we're talking about a forensic facility. Would it make more sense to just say interim forensic facility? I'm just not sure, like, why are we using that phrase? We introduced something here that isn't mentioned anywhere else.
Let me take a moment.
Okay.
But yeah.
It would be a much easier change than trying to change every time forensic facility is mentioned to interim forensic and competency restoration program.
Understood, yeah. We're true.
I agree with that.
All right.
From a technical perspective.
I like that. I like
Would
that
the
phrase, but
definition of facility cover it for program? That kind of what?
yeah, I mean, maybe,
When I hear facility, I think brick and mortar.
right, yep, and in the definition, we have, it's a secure. That's the page the definition is on, but
Definition
It's 19.
has to say that it's the facility means a
it's a
program.
locked, secure, so if you, the definition of forensic facility contains the word facility. Means a locked, secure facility where, and then it names the things that happen there.
But I don't
The
think it means-
programmatic,
it doesn't necessarily mean that you have to construct some separate building.
right.
So I don't
right.
think there'd be any way that any problem with interpreting that to mean for the first 3 years. Let's say we use facility everywhere.
Yeah,
It could just be,
and if it's an interim forensic facility,
Sure.
maybe that differentiates it from permanent forensic facility.
right, because it's saying an interim in that section.
Right, in that rulemaking. thing.
Yep.
It just seems like a way to avoid potential confusion. I don't, because I don't know what that confusion may or may not lead to, but I wouldn't want there to be confusion.
Well, I think it's right. I think either way could work. In other words, you could, by saying programming, I think it is a little more clear if you said facility. But if you still, if for other reasons you need to say program, I think because of the fact that it says it has to be consistent with the standards and procedures of 9, 10, 11, that if for the interim 3 years, that it's really means program.
Yeah, if there's a reason that you need to say program, then I totally.
So I think we do because of the appropriations amendment. And the idea, the appropriations amendment says you can't be developing forensic facility. We'd either have to change that amendment to say the permanent forensic facility,
Mhm.
or we just leave that and continue to call it program. Because with the program, this amendment of appropriations wouldn't apply.
Right,
It's specifically talking really about the physical facility, and it could get confusing.
Yeah, I think it could get
But I mean,
confusing when
so-
it's always called a facility and then it's just called a program. in one
So, I mean,
instance.
I can talk to, I mean, the one answer would be to change it to amend, or have a substitute amendment from
Appropriations.
appropriations that says permanent forensic facility. I think that would take care of that issue, yeah, Ken.
Why couldn't we just take that language there that Angela's talking about and just put it in the legislative intent, like to be at a such and such a date or something like this, that it will be known as whatever the heck it is.
Program.
Yeah, and then that wipes away any of the question marks going forward with the rest of the bill. It will be known as that date to be changed, and then it's very minor.
Except that the legislative intent is really talking about the permanent facility. So it may confuse that if we do that.
Oh, you lawyers always gotta come up with something.
That was good. Though. I know that was good.
So there's no easy,
Yeah, I think the easiest fix perhaps is I'll talk to Trevor to see if they can have a substitute amendment to clarify that it's permanent forensic facility. I'll see if we can actually do that and then call this an intern.
Yeah, and if I'm the only person who thinks this might lead to some confusion, then I can totally drop it. But it just seems odd to have this phrase appear
Yeah,
in one place.
I've had this conversation with Eric a couple times.
Okay.
So let me just check, if it's not hard for appropriations to change that.
Yeah.
Then I agree that we can just add that, but if that looks like it's gonna throw a wrench into it, then.
Right, and as long as someone can tell me that it's not gonna like lead to some confusion in implementation or that there'd be some hang up in like,
we can do.
exactly. So let's say what we mean.
No matter how,
Yeah.
no matter how perfect the language is,
There.
human beings are gonna have to implement this.
Let's help the human beings who have to implement this and use consistent terms.
I agree, we could try that. See what we think.
Oh, well, just a thought.
All right.
I think you're done.
I think we are done. Yeah.
Okay. Coach.
Good morning.
All right.
Morning.
I think Angela's point's well taken, but also Representative Squirrel's comments about the thinking in language around the use of terms and the implications that he made. I'm gonna go back and listen to his testimony, but I think appropriations had it wasn't a hang up. It was a structural issue for them around funding. You know, program versus brick and mortar. So that might help us as far as determination of just using the term from start to finish, either one. But his testimony was pretty clear yesterday, and I've got to go back and listen to it, to be sure, because it was short, but it was pretty clear about the funding issue.
Right, yeah. But we have some not completely clear language in here, so we can look at that a little further. Okay, any other questions for Eric? So we're gonna have a new draft with those changes. I have to have a conversation with Tom about other issues expected this, and also need to know if anybody else wants to join the sponsorship, if that's okay with Tom.
Anybody who wants on and
So
more than welcome.
we will, while we're all here, We can actually move 606 and 937 because they are on the House calendar. If people want to look at the actual language, get the House calendar up on the screens. And yesterday we talked about whether we needed more testimony. I think it sounded like we didn't. We heard what we need to hear. So I would start with page 606, which is on today's calendar at page 3665. And like I say, we've had quite a bit of testimony on this, including a couple weeks ago from Carolyn Hansen, and again last week, and we heard from a number of other witnesses. I would like, at this point, it's not perfect, nothing, well, sometimes we have perfection, but it does have the model policy, which will hopefully really get more deeply into how to maneuver around the concept of third parties, which I know was the biggest discussion that we had in here. But this really, I think, advances just the logistics of the implementation of our current extreme risk protection law and RFA laws, if there's relinquishment of firearms under those previous existing laws. So I'd like to put a motion on the floor and then we can have discussion. And I think the appropriate motion, as I understand it, is to concur with the Senate proposal of amendment of H 606. If anybody wants to make that motion.
So moved.
All right, is there a second? Second. Any discussion? And this is just a straw poll as well. Yeah, go ahead.
Yeah, I'll say that I really appreciate the work done by the working group, and it's always kind of refreshing, I suppose, when a working group can come to a consensus, a decision that it's a set of decisions that seemed like everyone who testified felt I don't want to characterize it as good, but positive about. There were no objections, certainly.
Well, Chris Bradley was not a fan still,
But he wasn't a member of the working group. He was consulted, certainly, but I didn't hear any objections from Henry Perot, who's the
Right.
firearms dealer, who was a member of the working group.
I think I did, in fact, that you can get Chris to admit some positive things in it.
Yeah. So we hear there are so many groups and task forces and, studies and everything. Sometimes it's hard for those groups to really come to a pretty solid place. So I appreciate that they did that work and that they produced these recommendations, and that the recommendations that became this bill were all consensus or unanimous, as I understand it. So I think that's a really good thing, and I agree that there's still work to be done, and I look forward to continuing the work. And again, because of some of the testimony we heard, want to again remind folks, not that we all need reminding, but how important it is to get this stuff right for victims and survivors of domestic assault, especially domestic violence, and for folks who are subject to extreme risk protection orders. Like, all of this is really important work, and advancing it is can be is potentially life-saving.
Just my point of view real quick. I appreciate the work that's done. I think it's something that really needs to be looked into and facilitated. However, I really feel that it overlooks utilizing the third party more. Thanks to and it makes it more difficult that Vermont in recent history made its checks more stringent than the federal government did. But I think the third party use will help facilitate the quicker seizure of not seizure, but transfer of firearms to other people sooner, like the night of for the situation, as opposed to later. and it makes it easier for law enforcement and everyone. It puts it out in somebody else's hands, another barrier that it throws up. So that's why I'm gonna.
So isn't this advanced still? I mean, we're advancing in the model policy is going to help us.
Excuse me?
So advancing 606, doesn't that advance getting to the point of looking more deeply at third parties as well, or is this?
Who's gonna suffer from that in the interim? I'm very hesitant, you know, when people are gonna feel as though they need to transfer their firearms to other people. Instead of give them to maybe a shop who, if they don't ever get them back, may sell the firearms. We need to have somebody else named in that paperwork so that the shop doesn't do that, because essentially they're gonna own them at that point once they get to give them back. It bothers a lot of people. They're essentially transferring ownership, just like a title to a vehicle.
Yeah, and just to add to his way of thinking, do you really think that anybody's gonna follow that? I just don't see where this adds anything to it, besides probably the people that are gonna be in that stage of mind, I don't think are going to be thinking that way to go to pass another law that sounds good on paper, but the what you're trying to do for protections means anything. I don't think it adds any more protections. In fact, I almost think it gives a false sense of security to people, and I don't like that one bit. And in your experience, Rep. Oliver, am I wrong would that be kind of the way that people will be thinking?
Well, I just think there's always, you know, it's hard to stop a determined person, but putting up barriers helps. And I think a third party is also a barrier to get that firearm back. It's very, you know, makes a person have to take an overt action to do it. There could be a false sense of security. It's, you know, it's like we have security in this building, but 175, 200 people come through every day without getting screened. So nothing's ever going to be perfect. But I think it's very essential to remove the firearms as soon as possible in the process of this. And third party really sort of facilitates that. Without a whole lot of administrative work added to the situation, and maintain ownership. People don't have to worry about, they may not get as angry about it. That's just what I'm hearing. And that's what I believe. That's why I'm.
Zach, you all set?
Thanks, Chair. I agree and echo the concern shared by Representative Oliver and Representative Ghostland. But an additional concern that I would point out, and it's something that I shared with the Vice Chair, and I understand that there have been sidebar conversations about this concern specifically, but the secondary background check to get the relinquished firearm back, which somebody already owns, I think is an additional hurdle and burden that's being placed on the firearm owner that I simply can't support. Just in the rulemaking process, there may be hopefully changes made to that, but as the bill is currently written and as it's being considered as brought back by the Senate, I can't support it in its current form. So I'm also a no vote.
Yeah, well, I just want to add a note that the Act 64, which was the miscellaneous judiciary bill of 2025, did not, and that which contained this firearm surrender order compliance. We didn't task that group with looking at third party specifically, or, you know, beefing up third party relinquishment. And so I know that it's mentioned, in, I think in the model policy, the section, if I'm not mistaken. Or maybe I'm referring to it in legal removal of firearms from the scene of a domestic violence incidents and things like that. But so I think it's certainly work that could be done, but it's not the work that we asked to be done that led to this bill. And, you know, I just think it's important to remember what we asked people to do, and then they delivered on what we asked. And it was a disparate group, you know, of folks and people who have a lot of experience. And as does Representative Oliver, people who have experience with this, and they all supported these recommendations. So
I expressed my concern. Then.
I think it's time just to express it.
Yeah, so I also just want to look at, make sure I understood one thing here, that I do recall, I mean, we did have Department of Public Safety, we weighed in on this and do support this as well, and believe that it does improve the current situation. It may not be perfect, once again, and there's more work probably to be done. But you know, because of that, certainly I support this. So we have the motion on the floor, in the room, on the committee, is to concur with H 606. Is there any further discussion? All right, all those in favor, let's do a raising hands. Of concurring, 1, 2, 3, 4, 5. Coach and Barbara. There's a hand there, Barbara. There's a hand. Those opposed, raise your hand. So it's and I assume your hand's up on opposed. Opposed? Okay, yeah. So, 7-4. And so Angela can be prepared to report that. So why don't we move then to H 937, the miscellaneous judiciary procedures bill. I don't know how much discussion we need on that one. We've had testimony on it, and we had testimony on the additional amendment yesterday. So just to get this moving along, I would take a motion to concur with the Senate proposal of amendment on H 937. So, right. So is there any discussion? It seemed pretty straightforward to me. So all those in favor, please raise your hand. Coach and Barbara, Barbara has a hand up. Coach, miscellaneous bill. Yeah, I can put your hand up. All right, so that's 11-0. And are you game to report that since Barbara's not here? Yeah. All right, so just 193, there's going to be some additional language and additional amendments. And I do need to talk to Tom about one other concern offline, and then we'll be back with language later this morning. So we're adjourned.